Thank you very much. I don't speak Danish at all, that's why I will speak in English, although I will refer to some Danish laws as well. I've already had a nice introduction of the copyright laws, so that makes my task a little easier. Thank you very much for inviting me here to talk about such an important topic, such as the freedom of expression on the internet. Of course, it raises a lot of different issues, and I will not have the time to discuss all of them, but will limit myself to copyright and those issues that might be relevant for opinionated internet users, bloggers, vloggers, whomever they might be. So freedom of expression, this intersection, freedom of expression and copyright is a complicated one because the premises upon which both rights are built on can be said to be in direct opposition to each other. In the context of freedom of expression, everything is permitted except for what is expressly prohibited, whereas in copyright law, everything is prohibited except for what is expressly permitted. In practice, this means that once the two collide, courts must engage in the very difficult task of balancing the different rights. There are valid reasons why it is like this, of course, but the methodology of dealing with that is not particularly easy, and it's exacerbated by the character and amount of legislation that is involved. Copyright consists today of a lot of different instruments of law. Most of it is regulated on an EU level, of course, whereas freedom of expression is humbly contained in Article 10 of the European Convention of Human Rights and Article 11 of the Charter of Fundamental Rights of the European Union. By way of example, Article 10 simply says, everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. Now, this is not much for a court to go on if they have to set all these copyright instruments and try to balance them with this very short and concise freedom of expression that everybody has. But I will use the European Convention of Human Rights to show you how this is done in practice. But to begin with then, the European Court of Human Rights has said that Article 10 is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also those that offend, shock, disturb the state or any sector of the population. So criticizing or expressing unpopular views is something that falls within the concept of expression here. It even includes racist hate speech or adult content, even where the church has deemed it to be blasphemous. In the context of the internet, the court has said that the internet plays an important role in enhancing the public's access to news and facilitating the sharing and dissemination of information generally. It applies not only to the content of the information, but also to the means of transmission or reception. So if you're operating a platform where people can exchange ideas and information, you will also fall within this concept that we deem worthy of protection. In the case here, it concerned the Pirate Bay. I will not go into the details as I don't have the time, but the point is that the idea of expression is very, very broad. So it's not really so much about whether something falls within this concept or outside of it, but when can the exercise of this freedom be limited? And the court is very methodical in dealing with that. So for an interference with freedom of expression to be allowed, the interference must be prescribed by law expressly. It must pursue a legitimate aim, for example, prevention of disorder or crime or protection of reputation of rights of others, and be necessary in a democratic society. And this is the requirement that gives amount to a lot of discussion. What does it really mean? What is a value in our democratic society? What does it mean that it is necessary, even though it is in the law and serves to protect, for example, the rights of others? The court has made it clear that the test is there a pressing social need for limiting freedom of expression, but it has made clear that you cannot really use this in absolute terms. Instead, you're supposed to look at the circumstances. What type of expression are we dealing with? Is it political expression? Is it in the context of talking about a public figure or a private person whose private rights might be infringed? What is the severity of the sanctions? Would it be a crime? Is jail foreseen for this, or merely a fine, or merely a private sanction? And then tries to make this nebulous balancing exercise. Now, in the context of copyright, the problem is that, the problem is that the court has consistently made it clear that copyright falls within the concept of property that is protected under Protocol 1. So it really becomes two fundamental rights against each other: the right to property on the one hand, the right to freedom of expression on the other hand. And when that happens, courts, from the perspective of the Convention, courts are given more discretion to carry out the balancing act on their own, which in practice means simply applying the rules of copyright law. We call this discretion margin of appreciation. So the more rights are at stake, which are protected as fundamental rights, the more the national court is allowed to apply its own law in accordance with those provisions, rather than from the perspective of the Convention. Since more rules and more specific rules are contained in copyright law, when the two clash, that is really what the courts in practice look at. So it's really about what copyright law provides. I will not go through all of them since this was already presented before, but you may probably know that economic rights are granted by copyright, and moral rights. Economic rights, almost all of them are regulated by the EU today, so that is really where the discussion is going. You have the reproduction right that was quoted before, and something that is more relevant on the internet nowadays, really, communication of the works to the public, making works available. It concerns, for example, hosting information on server, publishing on a website, and linking. The court has held there's been several attempts to try to persuade the court, linking should be prohibited as a matter of copyright law. And the court has confirmed that if someone is linking to illegal content in the sense of copyright, so copyright protected material that has been uploaded illegally, then that will be a communication of the work to the public, but only if the linker knows that the material is illegal. So if you don't know that the material is illegal, it is not a communication of the work to the public. This is a bit of legal fiction, of course, as you can realize, but the point is that once you know, you cannot link. And if you're doing it for a commercial purpose, then it is presumed that you know that it is illegal. So that seems to prevent all the journalists from writing a very good piece of journalism on linking to illegal content and then providing to back up their claims examples of where you can, for example, watch movies illegally, etc., or a meaningful discussion of it, because if you know, you can't do it. And this brings a very dangerous part into copyright law, because at least in Sweden, possibly, and in Denmark, I would assume as well, once knowledge becomes a criterion for the prohibited act, criminal sanctions can come in. So jail or criminal penalties might become important here. This is a very recent case. We are still discussing it. What does it really? What's the consequence of it, and more are likely to come. But it seems to hit directly freedom of speech in such a way that you are, after all, not dealing with a copy of the work. You are only fictionally communicating the work which someone else has uploaded to the public. I won't go discuss this in details, of course. I unfortunately don't have the time, but to go further on, then moral rights, which are completely outside of EU law, it is a matter for our national jurisdictions to determine, contain two important rights: the right to claim authorship and the right to object to derogatory treatment. I took the liberty of referring to the Danish Copyright Act because it's the same in Sweden, so it was very easy to find. The work may not be changed or made available to the public in such a way or context that it is prejudicial to the artist's literary or artistic, what's it called? Anseelse or egenart. You'll probably understand this, right? The point is that this provision allows, it is detached from the economic rights, but it allows the author to claim that it's been in a context, it's been put in a context in which it is prejudicial to me. So if you don't like it that someone is, for example, criticizing your work, it's putting it there. It is something, if you really, really want to get it removed, that is probably that someone will take, because it concerns a very subjective element here. Now, it's not going to work every time. There are rules for this. Mostly, it tends to refer to putting it in a commercial setting, in advertising, or where it creates the impression that the author is endorsing, for example, the other claims that are made in this other context, where this actually works. Now, as you know, there are exceptions to copyright. A very important character or feature in European copyright law is that all the exceptions that we have are exhaustive. So we cannot have more, we can't make more, compared to the US, where there is a fair use standard, as it's called, which is flexible and does not list specific uses that are available. Quoting or referring to using disseminating public information is always possible. It's the same provision as in Sweden, because copyright does not provide protection for public information. So that is fine. But with regards to quotations, which is a very important permitted use here, everyone can copy or can make a quotation from a legal work, offentligt gjort verk, which means a work that has been lawfully made available. It's a legal work. If the citation is i överensstämmelse med, in a manner or in a context, in accordance with proper usage and to the extent required by the specific purpose. So one cannot quote as they wish. There are specific rules that have to be observed here as well, including the name of the author. For what purpose is it given? Does it serve that purpose? Have you quoted sufficiently enough, or are you quoting more than is really necessary? It's popularly assumed, and this is the case in Sweden, of course, as well, that this provision does not concern pictures or images. Instead, it is Section 23, also in the Swedish Copyright Act. However, there you can use fine art and works of a descriptive nature for critical and scientific purposes, if it is not for a commercial purpose, which also might make it a little bit harder, because if you try to use it on your website and there is a piece of advertising, because that's how you pay for the hosting services, one might make the claim that you are doing it for commercial purposes. It's very few cases on this to determine what that is supposed to mean. But more interestingly, this provision comes from the InfoSoc directive, the directive on the Information Society, where there is such a quotation exception. And while the text is more or less, or the requirements are more or less the same, the very interesting point, it has been made in a case by the European Court. Under this provision, member states may provide for an exception to the author's exclusive right of reproduction of the work. The provision is intended thus to preclude the exclusive right of reproduction conferred on authors for preventing the publication. Now, as you saw, there is another right, communication to the public. It would seem that quotations can only be made because they are accepted from the reproduction right, but not from the communication to the public right. So you can copy the relevant parts, but you cannot publish them, because that's another right. This is, of course, absurd, but it is not contravening a very important canon of interpretation in EU copyright law, which is exceptions must be interpreted narrowly. Now, given this statement here, it would seem that this provision is not fit for the 21st century that we simply live in. I have never heard of a case that someone would try to challenge this. Of course, we must assume that the exception is working. It has to work, because even though I might copy in the sense of making a partial reproduction in my quote, I must be able to publish it. It would serve no purpose otherwise. Yet, it seems to provide such a possibility here. Another important exception are parodies. These are contained in the Information Society Directive in Article 5.3k. Used for the purpose of caricature, parody, or pastiche. The court has defined what is meant by this. Essential characteristics of a parody are to evoke an existing work while being noticeably different from it and to constitute an expression of humor or mockery. I think Sweden hasn't introduced this specific provision, even though there has been a case concerning a parody where it was allowed. You might know this boy, it's Alfons Åberg. I don't know if you've heard of the case. The case concerned reporters who had put together or taken excerpts from Alfons Åberg movies or children cartoons and put them together with extracts from the Danish Pusher movie, essentially making Alfons Åberg as a drug dealer. And then, of course, you have his name that signifies something in Danish as well, which is not the case in Sweden. So, of course, Gunilla Bergström raised a claim in court, and it was under the Section 3 concerning the moral right to object to derogatory treatment, that it was put in a context in which it is prejudicial to the author's literary individuality, for example, or reputation. And the court allowed the publication of this conversation, as it were, on the basis of Section 4 of the Copyright Act. This is the same provision in Denmark, whereby it is not an infringement if, although you have used someone else's work, what you have created is in effect a completely new and independent work. What this means in practice is that for a parody to work, it has to be a completely new work in a copyright sense. It has to satisfy the object of the requirement of originality. And that is different from what the EU court has made clear in the Deckman case, that for a parody to enjoy or for to be possible under Article 5.3k, the parody itself doesn't have to be original. So I am sure that if this case came up again, because this was before the implementation of the EU law in Sweden, if this case came up again, it might have been decided slightly differently than it was at the time. And this is really what copyright provides in the context of uses that have nothing to do with the reporting of media as well. Simple uses which one would argue are unharmful or nevertheless restricted by quite stringent copyright rules. So the question is, what do we make of freedom of expression then? I mentioned the Charter of Fundamental Rights. The court has stated, the EU court, the protection of the right to intellectual property is indeed enshrined in Article 17.2 of the Charter. There is, however, nothing whatsoever in the wording of that provision or in the court's case law to suggest that the rights are invaluable and must for that reason be absolutely protected. In the context of measures adopted to protect copyright holders, national authorities and courts must strike a fair balance between the protection of copyright and the protection of fundamental rights. The case did not concern the exceptions at all, but it was resolved with reference to fundamental rights. So the question that transpires is really, can we use freedom of expression as an external constraint on copyright protection above and beyond the exceptions that we have there and that are often argued are the embodiments of, for example, freedom of expression? To me, it seems that this indicates that the answer might be yes, but the German Supreme Court has actually asked this exact question, so we will find out very soon whether that is the case. One such important aspect is, can we use freedom of expression or the human rights to introduce new exceptions, despite the fact that we cannot introduce new exceptions? And it seems that the answer could be yes, because now they want to introduce new exceptions in the copyright modernization policy. I will finish here. Thank you very much.
Just one question. I was wondering, how do you prove knowledge? You were talking about
That's actually a very good question. I don't know.
Okay.
We don't know what that means. The problem is that in most cases, from an ideological perspective, you don't really have the competence to determine if something is protected by copyright or not, nor do you know the context in which it was uploaded. There's a very interesting case from Sweden where they actually applied. It was the first case where they applied the ruling of the EU court. which concerned posting a film on YouTube, and there was a Belgian company that linked to a movie which was on YouTube, a home video that was on YouTube, which turned out to be illegal, actually. And they won, because it was a presumption: you're a company, you're a media company, you know that it's illegal, show that it's not. They didn't show it, they didn't try, of course, and the author won. The problem is that, as I think you showed before, YouTube's terms state very clearly you have to have the rights. So for a company, even where you have to debunk the presumption that you have the knowledge, what else can you do if not to show, well, we go on YouTube, we show that, we check that you're supposed to have a right. It's a home video, not the latest Hollywood movie, so there's no suspicion here, really. Where would I upload, if I wanted to be a famous internet star, what would I do with my funny private video? I would upload it to YouTube, of course, right? That's a problematic requirement, or at least a presumption here as well.
Kacper, Szkalej,
Yeah.
thank you.
Thank you.